name is George Parnham. I'm an attorney. I have been practicing for 42 years, and I am proud to say that I am a recently sworn-in member of the State Bar of the State of New York. My specialty is lately the defense of individuals who are mentally ill, and I would like to discuss with you the particular statute that applies to insanity in the state of New York, and how fortunate the State Bar is, particularly the defense bar, in having the language of such statute, statute 40.15, that relates to insanity and mental disease and or defect. It's fortunate because it permits psychiatry to become once again part of the courtroom equation, and to permit qualified psychiatrists to testify as to the mindset of the individual that finds him or herself in the jaws of the criminal justice system through no mental fault of their own. I'd like to talk in terms of the definition and break it down. In the state of New York, the definition relates to an individual having a substantial capacity to understand and appreciate and know the nature and consequences of his or her act, as well as to have the substantial capacity to appreciate and know the wrongfulness of that act. It's important, first of all, to understand that the foundation of the insanity defense is mental illness. And what do we have to do in order to prove that an individual is mentally ill? What tools are there that are necessary, and if they exist, in order to present to a jury, to convince a jury to determine that the individual lacked criminal responsibility? Very simple. We look at the individual's case history, background, to determine whether or not there are any mental health records. Psychiatric testimony is very important. It's also very important to have individuals interview, obviously psychiatrists, to interview and evaluate your client. Family history is important. The nature of what occurred is important. And is a caveat to this presentation, a practical tip to those practitioners that are confronted with cases such as a case involving an individual who is mentally ill. If that person appears to be psychotic, once you get your client and you talk to your client, or you talk at your client, and your client is, for instance, experiencing disorganized thoughts or not being able to put words together properly, get yourself a video camera and get yourself an expert immediately, and get that video camera into the cell. Use a marker if you can with the high sheriff. Get that camera in there and capture that person, because that person eventually will be on medication, and medication will work. There is no question about it. The person that the jury sees at the time that individual is tried will not be the same person that committed the offense, simply because of the change that that individual will exhibit. And that has an added advantage of taking away the anguished decision-making process of whether or not to put your client on the witness stand. It's important to understand that the substantial capacity, or lack thereof, to understand the nature and consequences of your act, and to know that it's wrong, that it doesn't have to be a total substantial capacity. For instance, an individual can have a surface knowledge of what he or she is doing, much like a child who, for instance, memorizes a song and doesn't really understand the meaning of the words, but nevertheless is able to recite the words to, for instance, its parent. Surface knowledge can be present when an individual is charged with an offense and a determination is made as to whether or not that individual has substantial capacity to appreciate or to know. Lastly, it's important to know that, and this is vital, that the court, after the presentation of all the testimony, will charge the jury after summation that the jury is not allowed to wander about in its decision-making process and speculate as to the effect of the verdict. In this case, should the verdict be an individual who lacks mental responsibility for the offense charged. Rather, the judge will instruct the jury that because of a common lack of knowledge as it relates to what really occurs, that person, if you find that person to lack criminal responsibility because of mental illness, then that person will go through a series of hearings and can eventually be committed to a facility for an indefinite period of time. Last point, through the eyes of the beholder, always have the jury to judge the actions of the client as the client sees her actions to be. And if the individual is truly mentally ill, his or her reality will not be the reality that you and I enjoy. And a jury has to understand and take that on and appreciate that.